Good afternoon, and welcome to the November Florida Family Law Section Facebook Live. My name is Amber Kornreich, and it's an honor to introduce today's topic and guests. Before we begin, we'd like to remind everyone about the upcoming CLE 3 Men and a Family Law Case Update taking place on November 17th at noon, featuring Ron Kaufman, Cash Eaton, and Ruben Dupay. Registration is open now on the website. Also, the 2023 Mid-Year Meetings and Family Law Review course is coming up soon, January 25th through 28th in Orlando. Stay tuned on Facebook for a message from Kristen Kirkner and an update from the Planning Committee. Visit the website at familylawflaw.org and follow the section on social media for more details. Today, we have a very exciting update program on emergency clauses and parenting plans, hurricanes, disasters, and more. This initial program, featuring Executive Committee member Mark Joseph and CLE Committee member Anastasia Mahone, commenced back in 2020 at the beginning of the pandemic. Since, our state has experienced massive storms and other unexpected events. These events, without a doubt, affect our lives personally as family law practitioners, our firms, our courts, and of course, our clients. Without further ado, we are pleased to have Mark Joseph and Anastasia Mahone dive into this topic and offer us all helpful hints and ideas on how to protect our clients and their families during these very uncertain times. Thank you.
Thank you, Amber.
Thank you.
So I think that it's important that we get started in talking about the emergency clauses and parenting plans and how really at the end of the day, we need to first define what would be an emergency, given that our state, at least in my practice, in my experience, I've seen very few parenting plans that actually address emergency situations, despite the fact that we're in Hurricane Central and that every year we have a recurring hurricane season. So, what are your thoughts, Mark, as far as how we would define an emergency if we were to discuss that sort of thing in a parenting plan?
All right. Well, thank you. But what I would say is when it comes to emergencies, an emergency, there's the objective factor and it is subjective. And I would say that emergencies would really be based on the family. I don't believe that there's any two families that are situated exactly the same. I think every family has their own separate needs and things that need to be addressed. So it can be an emergency. So I do agree with you. Unfortunately, not enough parenting plans do address these type of emergencies, but it is something that as practitioners, we should take into consideration and think, you know what? Based on the facts, based on the circumstances, we should have some built-in emergency provisions to allow for this. But obviously, we have acts of God, natural disasters, declarations by local governments, state governments, federal governments that could obviously constitute an emergency, which would essentially be something that is so urgent and you couldn't consider unforeseen that can disrupt the parenting plan as is.
And I very much agree with that, Mark. So I think that a lot of it, we could find, our guidance in defining an emergency in a parenting plan based on the contractual concept of force majeure. And so, implementing that sort of thing to define an emergency so that parents know when this particular term would be triggered in their parenting plan. And so with that said, when it comes to addressing emergency circumstances, there are quite a few ways to do this. And at the end of the day, I think that we all must remember that everything that is done in an emergency situation must be in the best interest of the children. And so because that oftentimes is lost, particularly with our high conflict parents.
Absolutely, I would agree.
Yes.
And I think something else that's worth noting is there is the Florida statutory requirements of what makes a parenting plan. And for those who may not be as familiar, when you look at the statute, there's only like 4 real things that a parenting plan needs to have. which is a definite determination as to what the schedule is going to be between the parents and the children. Consideration as to who's going to have, what type of parental responsibility and how that's deviated, whether it be shared, ultimate, or sole. A consideration for, I believe, health insurance and other expenses. There's like those 3 to 4 things statutorily is all you need for a parenting plan. So everything else that we take into consideration, that we look at, the standard Supreme Court form that a lot of, some practitioners base off of, and pro se's more likely using, even mediators, only need those 4 things. So all the extra stuff is more just through practice and just experience of saying, hey, we need this. And I do think that, especially dealing with what had happened with the pandemic, and just us thinking about, hey, we have natural disasters. We're in a state that does have natural disasters, and other places have these certain things that can occur as well, that we do try to be more preemptive in our parenting plans, and emergency should definitely be one of those things we look at.
And I agree with you, Mark. It's really more so because we only have certain requirements in for our parenting plan statutorily. It's more so on the practitioner looking forward thinking in terms of, especially when you have these contentious co-parenting relationships, and the idea that we may be dealing with these circumstances in the future, and how these parents may do this. Because I think at the end of the day, no one wants children being exchanged in the middle of a hurricane while there's an active hurricane going on. That puts everyone in danger. Most importantly, it puts the children in danger. But, out of principle, there can be situations where people are attempting to have this forced, and someone that may not agree or does agree, or people that actually do this. But that's certainly not what I think, foresee as practitioners, because we have seen throughout the state if we think back in terms of the hurricanes that have hit us in the past, there can be lots of different situations that render the parenting plan sort of impossible or impractical, where, people, for example, there's flooding, maybe there's, an inability to ingress and egress from a property for whatever reason, things of that nature. And all of those things could be quite dangerous. And, planning in advance may be the best practice when it comes to contentious co-parenting.
And you're right. And then there's also the other end. There's our first responders and people who have employment that requires them to actually do the opposite and to respond to these natural disasters. We have, our law enforcement, paramedics, firefighters. I know utility workers are usually ones that are first on the scene to either start repairing or remediating some of these disasters. And that, in the inverse, can affect the parenting plan. And it's not purposeful. It's just, obviously, it's within the job, within the parameters, which, again, understanding if you have someone who is a seasoned firefighter in that, and they plan on doing it throughout their career, that's something you consider. No different than the type of unique work schedules that firefighters tend to have. Those considerations should especially be made within those if there's any emergency work situations that occur. And again, some of this we say is preemptive, but in reality, just understanding each family in each case, we know what could come up just based on the potential. So I agree 100%.
Very good point, Mark. And I think that, so in all actuality, what do we do about this? What sort of terminology can we place in parenting plans in order to protect children, and to make sure that, parents have something to look to for guidance in these sort of situations?
Well, okay. Well, before we go into the provisions, I think it's very interesting because, this would be presuming, we put them in the parenting plan. And of course, if everybody agrees, then it sounds good. But then we also have the fact that sometimes we litigate these things and we have to go to trial and we have to persuade a court to kind of impose these type of things. So the question of pleading and preparation, I think, is important. But I do think that requesting, whether it be in mediation, your pleadings, or to the judge, suggesting that the court take in consideration emergency or even exceptional provisions, I mean, some people don't like the word emergency because it has it has a certain implication. But when exceptional or exigent circumstances occur that may require the parties to deviate from the time sharing schedule, and it could be, again, acts of God, as I mentioned, but it could be something simple, life events or situations changing within the family. So I think just kind of thinking forward, and even some provisions that say, hey, this would be considered, or setting a definition of what an exigent or emergency circumstance would be, and then going from there, adding those provisions. I think that'd be a good start. And what the language would look like is really per person, per situation. We don't know, what people may want to do. And obviously it makes it difficult to, at some point you're just trying to really get a case resolved on the meat and potatoes. Again, the time sharing schedule, the decision making, parental responsibility. But I mean, these are things we really want to look at if we want to support and help Florida's families get in agreements that can withstand the 18 plus, well, about 18 years, or that they will have to operate within this parenting plan. So I don't know, is there any thoughts of idea provisions that you may have had or thought of and used in your practice?
Sure. So, well, I think that it's really just important for people to consider various things that can happen, or various things that they may want to address, or how they want to address it. So, for example, when disaster strikes for whatever reason, however it is defined by the parenting plan, that's first, we need to define it. Then after that, we can talk about whether or not the parties will follow all local, state, national, whatever mandates that come down, the orders that come down. And that includes shelter in place orders, if there's an evacuation order, and for one parent or what have you. Obviously, assuming the risk by an adult is different than also placing a child in that circumstance, especially when the other parent doesn't have to evacuate. And in addition to that, thinking about, for example, who may have, in the aftermath, who may have electricity versus who may not. Who may have a habitable environment to enjoy time sharing versus who may not, and how is that defined? But those are all things that I think that parents should think about, because so that the parents do not get caught up in the idea of my time, my time, my time. Whereas, instead it's a best interest analysis for the child, and how to evaluate what's in the best interest of that child. And also ensuring that there's that maybe there's a clause that says, during when there's an active hurricane, tropical storm, whatever, however you want to name it, whatever you want to call it, whatever's going on, that no exchange is expected to take place. We take these sort of things for granted, but it's not as clear cut to every family, to every parent.
And I think you hit a couple of good points there that I definitely want to emphasize on. One thing I'll say is, a lot of families, to my surprise, because I actually learned about this in some of my cases, they have safety plans, like literally in their personal homes, and they have safety plans for everything. Like, if there is a natural disaster happens, if there's a fire in the home, and a lot of families have this, and they kind of instruct and prepare their children for it as part of the understanding of everything. But I don't see why within the extended family dynamic, why they can't have that as well. So I think, having that type of safety plan is very important to consider and have your people talk about. And we do take it for granted overall, because we always hope that these families can work together, and, when these natural disasters happen, that, the situation, takes precedence over everything that happens. And I'll give credit to Florida families in my experience. They tend to be pretty good with that. But unfortunately, we do have a lot of these high conflict families who just, for whatever reason, can't, they don't want to do that. And one of the things I think will really help in the provisions that you talk about, the suspending of the time sharing and things like that, is I think the entitlement to make up time sharing. that when these things kick in, that the parties shall work together to make up any sort of timeshare or inconvenience made by the parent. And at the end of the day, these parents can always use these parenting plans, or they can deviate as they see fit. But we definitely want to make sure that both parents have a vehicle in which they won't be held, they won't be punished if they fail to do the time sharing based on circumstances in exigent situations. But they can also get that time sharing made up, and it's not a fight in that situation as well. So I think kind of creating that balance in a parenting plan, and even if you have to present it to the court, I think is very fair and equitable, because both parent, acts of God in these situations don't have bias. It can happen to one parent one year, another parent another year, one thing, one worse. And what we want to do is make sure we have an agreement or a plan in place, parenting plan in place, that allows both parents to benefit and or be able to think outside of themselves and not feel like they have to give up something or be punished later if they do it.
I 100% agree with you. I think that that's what's necessary in order to, for the families that can't work these things out. It's necessary for us to have those sorts of provisions and entitlement to make up time sharing. And, I would say that, some other parents may decide to just simply state that in the event of a natural disaster, or when something of this nature occurs, that everyone will conduct themselves in the best interests of the child or children. Now, there may be some enforceability issues with regard to that, because it doesn't necessarily spell out what, that's subjective,
Yeah.
as far as what that would be. And, anyone that's faced with contempt would have to be on notice, of course, for what they could possibly be held to answer to or for. But it's worth considering to possibly place into your parenting plan, if nothing else can be agreed upon.
Yeah, no, and it's true. I mean, at the end of the day, in terms of finding contempt, that obviously be the issue. But then you also want to, it's unfortunate because a lot of people would like to avoid the court system when it comes to parenting or not decisions. But you also want to have people have an outlet, and also as well as a deterrent. So, having something that within these circumstances, something as simple as both parties will operate within the best interest of the children to make decisions that take focus on the best interest of the children, I would believe could be enforceable with that determination. And even because at the end of the day, I would suggest to my clients, if I have to file a motion explaining your actions and their actions, and this provision is in place that says we're going to focus on the best interest, you're going to have to be able to tell me what you did, why you did it, and how it's in the best interest of the child or children. If you can't do that, then yeah, you might have been in violation. If you're telling me that you were without electricity in a flood zone, a foot in the water, to the point we've seen the videos where, alligators get into the home, how that's in the best interest that you didn't exchange the child or, have the child relocated prior to this, and you knew you were in a flood zone. That's something we have to take up with the court. And that's a very difficult position, because remember, these judges also live in your circuit area or live in Florida, and they're going to be making these decisions, so they're just as aware of the circumstances and how serious it is. So at minimum would at least have that parent think, okay, at this point there's a balance between taking liberties with the language and just outright just going against it. So I still think it's worth it even put it there, even on paper, to at least deter that non-best interest of the child behavior.
I completely agree with you, Mark. I do. Is there anything else that you think we should address here with regard to these emergency provisions?
Just slightly. I think, and basically to culminate everything we've kind of discussed, we talked about acts of God. We obviously talked about situations within the family, as well as unique needs of the family. Like, we have things like asthma attacks. We have children who have, medical necessities, family members have medical necessities. We have people who have sensitivities to situations, like whether it be pandemic related or otherwise, that, I mean, people really want to think about and have these provisions kind of put in place to at least just consider it. So I think, you know, as practitioners overall, and even pro se's who may stumble upon this, they should really think about these situations, not when the times are at its best, but when the situation requires us to be, you know, not parents, you know, but humans, and, you know, be protectors and supporters of our, not only our children, but our extended co-families. You know, people don't like to think that, but all we're doing is the family is maybe separated, living in different homes, but it's still one family unit. So I think to implore people to take those considerations and look at the facts of each individual case and try to be preemptive, I think would save us a lot of time, energy, and litigation within the family.
I agree.
So, I mean, if not, I mean, I think that's all there is. Is there any other notes we should, any other thoughts that you want to leave us with, Anna?
Uh, no, I just think that, it's very important and, in the best interest that everything with regard to a parenting plan be done in the best interest of children, obviously, at all times, including in times of emergency and times of tragedy. And that may need to be addressed, and it depends on the family that you're dealing with. But it is up to us as practitioners to bring it up, to have that discussion.
Oh, I agree.
Well, thank you very much, everyone, for tuning in, and we appreciate you.
Definitely appreciate you, and take care till the next one.
Yes.